Greetings, family. Welcome to my YouTube channel. I want to thank you for the support, for those who have subscribed, for sharing, even for commenting on my YouTube channel. Your support is much appreciated. Today, I am going to be talking on when and how to approach the small claims court when you are owed an amount of money. This money must be, the limit is 20,000. So it's 20,000 or anything below 20,000. You can approach the small claims court. And all these small claims court are based at the magistrate court where you stay. So it's not like there's a building called small claims court. No, small claims court is a court within the magistrate court. So depending where you stay, you go to the magistrate court of the area where you stay. And when you arrive there, you tell them, I'm looking for the small claims court. And they will refer you to that particular division, which is situated in the magistrate court. So the matters that can be taken by the small claims court, the limit currently, it's 20,000 or less. It just keeps on going up. Well, I wouldn't say yearly, but from time to time, the figure is reviewed. I remember many years ago, it was 7,000. But at the moment, currently, it's standing at 20,000. That is the limit. For small claims court, you do not need the services of a lawyer or legal representation because the proceedings there are very informal, very casual. You get to present your side of the story, and the commissioner get to ask you questions to clarify some of the issues where there may be a misunderstanding. But let me not ride the cart before the horse. Let me start by the first step. The first step will be there's somebody who owes you money. It may be because you borrowed them or you rendered a service, or for whatever reason, they owe you a certain amount. Maybe it's 2,000, it's 10,000, it's 15,000, but it cannot be more than 20,000 as I have illustrated, unless if maybe this person owes you 21,000 and you are willing to forfeit the 1,000 rent and you just want to get the 20,000. So you start by number one, communicating with this person, as it is obvious to say, please remember that you owe me. Can I please get the money? We have agreed on such and such a date, but until today, you haven't given me that money. So you can either call them telephonically or you can send a message in writing to remind them. That will be the first step. And if that does not happen, we move to the second step, which is now a letter of demand. You can write the letter yourself. This letter of demand must state the facts, that you remember that we agreed that after I have done ABC, you're going to pay me on the 15th, and this did not happen. We agree that, okay, can I please extend it to the end of January? And I did extend, and still you did not pay. So you state the facts that led to that debt. And even there, you specify the amount when you write that letter of demand. To indicate that this is how much you owe me, this is what happened, this is why I say you owe me, this is what you specify in the letter of demand. And then you deliver this letter. This letter, it cannot be an SMS, it cannot be a WhatsApp. Maybe when you start the first step of contact, it's where you can send a WhatsApp, it's where you can send an SMS, it's where you can send an email. But now, when you begin to write a letter of demand, that will be the beginning of what I will call a formal process, because this letter is a prerequisite to you getting the summons. Before you get the summons, because before you are issued with the summons, there must have been a letter of demand that you would have written, where you state the facts, where you state the amount that you are owed by this particular person. And this letter must be delivered in person. Yes, you must deliver it in person, or you can send it via a registered post, that is via the post office. So once that is done, and the person does not react in that they do not pay you, you wait for 14 working days. This 14 working days, this is how it's calculated. Court days are usually calculated as working days. In other words, Monday to Friday. Weekends are excluded. Holidays, public holidays are excluded. That is in South Africa. So you'll be counting from Monday to Friday, and then from another Monday to another Friday, and then from another Monday to another Thursday. That will be 14 days. And then it means that the third Friday is then that you can approach the court to be issued with summons. There are instances whereby some people in the process of drafting a letter of demand, they can make a mistake. And then when you go to court to approach the small claims court, for example, a practical situation where I was involved in, this person said, no, I have already written a letter of demand, only to find out that she actually sent a WhatsApp and then followed it up with an SMS. So now the court says no, email, WhatsApp, SMS, for the purposes of a letter of demand as the beginning of a so-called formal process, for lack of a better word. It's not acceptable. So what happened is this, what they regarded as a letter of demand, was not acceptable to the court. So the clerk of the court himself or herself can give you a letter of demand which is standard, which they just give to you, or they fill whatever details that is required, and then they stamped it, and then they gave the person concerned a letter to say, okay, take this letter now, which we are going to start our step number 1 or 2, because it's now letter of demand. Take it to the police because they had stamped it. So in other words, it become into quotation court order. So the police will accompany you to that particular person's place to go and deliver the letter, because you know where they stay. So now this is how the process started. So in other words, the process could have started with the person writing a letter themselves, delivering it in person, or sending it by registered post. But this time, because they did not do it correctly, the clerk of the court gave them a new letter of demand, so to say, to start the process afresh. And they stamped it, and this person was expected to take it to the nearest police station for the police to accompany them to go and hand over this letter of demand. So it can happen that day, that way, I mean to say. So what happens is you start to calculate your 14 days, because you remember we said that after a letter of demand is issued, from that day, you count 14 days. After 14 days, if nothing happens, it's then that you come to court for summons to be issued. So what happens is when 14 days expires, you approach the court, the clerk of the court. When you come to the clerk of the court, you come with a letter of demand. The letter of demand, the very letter of demand that they gave to you, because they gave it to you, they give it to you in 2 copies. Or if it's the one that you would have written yourself, you come with a copy. One of the copies of the letter of demand, it was 2 copies. So one is given to this person. The other one, it's the one that you would use as proof that this person was served. If you used a registered post, there would be obviously a slip as proof that this letter was mailed to this person. So you come with that copy, you come with the contract that you entered into with that person. If there is any contract, you come with it, and you come with the contract. And then if there is any contract, yes, you come with it. And then you come with proof that this person was served. It's either where he signed or the pay slip, the post office slip. You must come approach the court with the personal details of the person. This means you come with the name, the surname, the cell number, the address, all the necessary personal details. And then once you come with these details, the clerk of the court will issue the summons. In this summons, the clerk of the court will specify the date upon which this person and you yourself will have now to come to court. Remember, there was a letter of demand. Now the clerk of the court is issuing summons. These summons can either be delivered by you or they can be delivered by a sheriff. But you must remember that a sheriff, they charge for delivering these court papers or court documents. So you can take it yourself or the sheriff of the court can take it on your behalf. In it, the summons will specify the court date. After 14 days, as I have said, both of you have to be in court. And the court proceedings, as I said, they are very informal. You don't have to be intimidated, even if you don't have a lawyer, because a lawyer is not required. They will kind of help you by asking questions. The commissioner will be asking you questions because on the day of the court, it's the commissioner now who will be working with you. The commissioner of the small claims court will play that role of a judge or a magistrate. They'll be asking clarity-seeking questions to enable you to present your case well. Because some of the things as a layman, if you are a layman, you may omit, not knowing that maybe it's not necessary for me to say ABC. So yes, they will ask you questions to seek clarity. And on the court day, of course, you're coming with proof, as I said. You also will come with proof to substantiate your facts. For example, if you say, as an example, I gave this person, I borrowed him 2,000. And for some reason, this 2,000 was deposited from your bank account to their bank account. Obviously, the proof that you can bring to substantiate this fact is you by getting your bank statement for that particular day when you transferred those funds to his or her account. That will be proof enough, or any other information that will assist you to substantiate the fact that indeed this person owes, or in fact, this person owes you. So as soon as the court takes a decision, the small claims court, in your favor, this person is expected to pay you immediately. Immediately. If they say for one reason or another, they cannot afford to pay, the court in chambers will conduct a mini investigation to establish their financial position. And if indeed after investigation, the court is convinced that this person cannot afford to pay you, the court will assist with coming up with a payment plan. If he owes you 2,000, probably there can be a plan to the effect that he or she pays you 500 every month for the next 4 months. That can be a payment plan because he does not have the means after the court has conducted an investigation and established that fact. Now, there are instances where this person has money, he doesn't want to pay, or there is a payment plan. Even that payment plan, he does not comply with it. He does not do what was agreed upon in terms of the payment plan, that this is what he will do. He will pay you 500 every month. He doesn't do it. So in other words, there is failure to comply. So what will happen is now this matter will be referred to the magistrate court for execution processes. Now, this is as far as I'll go. Maybe next time I'll talk about execution processes as to what this will entail in detail. But obviously, at the end of the day, some of his properties or whatever, or even his salary will be attached. So it will just be depend on the outcome of the execution process by the magistrate court. I thank you. I really appreciate your support. Please share this very important information. Don't keep it to yourself. Please comment. Please, in your comment section, You can ask me legal questions, but not for me to give legal opinion, but just to ask questions based on this particular topic. Not to say, advocate, I have this problem. That one will need proper legal representation, and it means that you approaching an attorney of your choice. Thank you very much. God bless you.